This is Matt Acock. I've created a document to assist real estate agents in understanding the new TREC contract changes that took effect November 2nd, but are not for mandatory usage until January 1st. The purpose of this guide is to give you just a quick overview about all the different changes that have happened to the various contracts and to explain some of the reasoning behind those changes. You can follow along in this guide and it'll give you a great breakdown of everything that's been implemented. So you'll find here we talk about the differences in the language on the draft forms, which you can download by going to this link here. The added replace content by the broker lawyer committee, remove content, add or replace content for the final ruling, as well as the stuff that the broker lawyer committee tried to implement but did not make it into the final cut. As we go through everything, you're going to find in this document we really break down all the changes for you. Not going to cover it in this introduction, but what we're going to do instead is go through each one of the documents one by one so that we can show you exactly on the document where everything's changed. The first form to change is the 1 to 4 family residential contract. This is where the bulk of the changes that you guys will actually see takes effect. This is the contract you use more often than any other, and so we're going to spend the most time on it. One of the things that we really like about these changes is the modification of items 3 and 4. Historically, we have had all the loan information split between items 3, 4, and the third-party financing addendum or seller's financing addendum. And now what we've done is we've taken that information and just compressed it into just the addendums. This has eliminated a ton of confusion, especially whenever it came down to what was a credit approval situation or a property approval situation. So by going through here and eliminating a lot of the bulk in this section, we've been able to create a more comprehensive addendum that's easier to understand and read. And we replaced all of this financing information with a big disclosure. Okay, guys, when you are a real estate agent or related to a real estate agent in a transaction, you're required to disclose that you have a license. This is a great way to get sued if you don't put this in the contract. So instead of having you guys write that in special provisions, broker lawyer committee has agreed that it is important to put it on the very first page. Guys, TREC is really tightening up on disclosures. You need to make sure that this information is in there. Disclose, disclose, disclose. As you move along, you'll find all the third-party financing information is gone. Great. We didn't want it there anyway. It took up too much space. So we've got that in an addendum, which we will cover later on. But we've added this provision here for water fluctuations. You're now required to disclose if you have a property that is near a 5,000 acre, impoundment. And so the whole point behind that is that they want to make sure that flooding situations are disclosed to buyers. Again, think of disclosure. Disclosure is what the TREC contract is trying to increase, trying to make sure there's more disclosure. And so here they've actually put in a disclosure that applies to all situations, so you don't have to make the determination for your seller as to whether or not this actually applies to their particular property. Another big one, hydrostatic testing. We've seen a lot of litigation on this issue. Basically, this is where they pump a lot of pressure through water lines or gas lines in order to test and see how strong those gas lines are. Sometimes they burst. When they burst, it creates a problem for the seller because the buyer may not want the property at that point, and now the seller has busted lines. Now get that authorization in writing from the seller. Most inspections are not going to include hydrostatic testing, but if your buyer is wanting to have that done, make sure the seller signs off on it. Otherwise, you could find yourself in a lawsuit. The next section is actually not in the final contract. You'll notice it's green and it has the line through it. That means it doesn't actually exist in the final form. But I want to bring it to your attention. Guys know with TREC, with TRIB, we're finding a lot of situations to where we have to do a redisclosure event, postpone closing, all the great headaches that come with that. What we are seeing is that if you are proactive in getting that extension, sellers are much more accommodating. Again, you want to make sure that the seller is aware that this is going to be a loan that TREC applies to, so that they know, hey, look, we could have an extension situation on this particular deal. Here, the broker lawyer committee saw that, and they wanted to provide an automatic extension of up to 10 days for a buyer in the event of a TREC event that causes a delay. That is not in the final contract. So you guys as agents, take this. If you are within 3 days of the closing and you don't yet have your final closing disclosure, go ahead and get that extension. You're going to need it. So just stay on top of it. Make sure your client's not ending up in a situation to where they cannot close. The next change is actually a fairly minor one that doesn't come up a lot, but if you're dealing with a property that has a tenant, sometimes that security deposit does not actually transfer to the buyer. It gets negotiated into the price. All this is saying is that the buyer does not have to tell the tenant that they actually acquired that security deposit. Now, they're still on the hook for it whenever that tenant vacates the premises. However, they only have to let the tenant know that they acquired the property. Looks like special provisions is still in here, unfortunately. We are always hoping that they'll remove this section, because more and more litigation comes out of a failure to complete special provisions accurately. Again, if you're putting anything at all in that spot, again, just make sure that you've talked to an attorney or a very experienced agent to make sure that whatever you're putting in here is actually useful. Typically, we find if you can make it fit in that space, it's wrong. This next part here is in the casualty loss section. This is basically where you have a hailstorm, flood, something that's covered by the insurance of the seller in the middle of the contract, and you still want to close and just assign those proceeds to the new buyer. Some insurance companies play ball, some don't. So this particular language right here does not put the seller on the hook in the event their insurance company will not allow them to assign those proceeds. The next big change is something that, of course, attorneys really like to understand because this is kind of how we can get paid. That's under the damages section. Damages section here, historically, there were liquidated damages. Liquidated means that the contract specifically tells you what the dollar amount will be. So we don't have to litigate over what damages are what. So we found a lot of times someone may actually only have $500 in real damages, and this particular provision would give them a windfall. Sometimes people would have $100,000 in damages, and this would give them less than what they're deserved. Now we can sue for what they really were harmed for, and what that dollar amount translates into is decided by the court, not by this contract. Finally, and probably the absolute best change that was made to this contract is the option period terminating at 5 p.m. on the last day. Not 5:01, not midnight, it is 5 o'clock p.m. That means you have to exercise your option period by that time or it goes away. And that hopefully will eliminate all of the late nights that we've had in this industry with terminations and stuff.